And this radio program with Marshall Chriswell is intended to be for informational purposes only. This information does not constitute legal advice. The law constantly changes. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. There's one of those right across the microphone from me. His name is Marshall Chriswell. Good morning.
Good morning.
Hey, we have homecoming weekend. We don't generally get into criminal law here, and I don't intend to now either. But for homecoming weekend, that means a lot of people will be gathering into town here in Indiana, and every once in a while people come over and violate some property rights, and sometimes you read of crazy lawsuits where somebody was in the wrong, shouldn't have been where they were, but got hurt anyway, and end up suing people for tripping over something on their property, or just some sort of thing has happened to them. I want to talk about homeowners and landlords and their obligations to make sure that their places where they are living or where they are doing business as a landlord are safe for people, and they want to make sure that they have all of their liabilities covered. It's very important, I would guess, for people to have that covered beforehand than afterwards.
Well, absolutely. If you're talking about particularly insurance coverage, you're going to want to have that in place in the event something happens. You can't go back and retroactively, get coverage for something that happened prior. Mm-hmm. So that's pretty basic. Landlords, property owners have an obligation to keep their properties in a safe and habitable condition. And when you're talking about potential liability for personal injury, you've really got to make sure that you do that the property is free from hazardous or unsafe conditions. Mm-hmm. Because even if it's not your tenant, all right, if you're a landlord and you rent to a group of students, your duty to keep the property safe doesn't just extend to those tenants. It also extends to any guests that they might have. And we know during homecoming and other weekends here in Indiana, those guests can, become a pretty large crowd.
Yeah. And so from a legal standpoint, when you are designing a lease or where you are trying to work in such a way that you're making sure that your liabilities are covered ahead of time, I would guess that they're working with an attorney in that case to make sure that, if I want to rent a place and I print up something off the internet and I say, okay, this has me covered, I'd want to get that reviewed. I wouldn't want to rely on that, would I?
Yeah, and even outside of the the potential liability for injury, just generally in landlord-tenant situations, and really all contractual relationships, the biggest problems I deal with in my practice stem from people that try to do it themselves, mm-hmm. Or do it on the internet. And we've talked about that before. I think we've had an entire segment on this show as to why you shouldn't try to DIY your legal life. Mm-hmm. And that's exactly what it is. There's just so much information available now that folks, and rightfully so. I mean, I tell people, go on the internet, sure, and look around and get an idea, but you are never going to be able to pull the document off the internet that you need that's going to have be valid and have the maximum effectiveness for your situation, your particular situation, by just using a form, mm-hmm. Or even using a paid service. You can go on the internet, you can get things for free. There are also paid services on the internet that like LegalZoom that you can go on and you can get, and so you get general forms. And again, they're general forms. They are not tailored to your specific situation. So that is the number one problem that I'm seeing in my practice is people trying to do these things themselves and clean up the mess later, whenever for a fraction of the cost and the headache, we could have drafted a document to take care of that.
Yeah. From the landlord's standpoint, I'm thinking when a tenant makes alterations or some other sort of does something to the property that brings other people on, and something happens to somebody, a guest, and it's because of something that the tenant did. What is the landlord's liability in this case?
So you're saying the tenant has a party and has too many people for the
Exactly.
Apartment to the capacity of the
Yes.
occupancy permits or whatever. So the landlord is going to want to have very specific terms in the lease as to that the tenant, either it's a no party clause or something like that, or limiting the number of people. You can try to do those things.
Can you really write that into a lease?
Well, there's a little bit of tension there with some other legal rights that the tenant has to associate with people, but you can there are regulations that regulate the occupancy of a rental property, a rental unit. So the tenant's got to comply with those laws. The tenant can't be making improvements to the property, can't be building building something to play party games on or hold additional people there, or all kinds of things that you would want to have specifically in the lease, so that the tenant's in violation if they do those things, and also you're doing what your insurance company wants you to do to limit the liability.
With pets, and particularly a pet that can get out of hand, maybe a large dog that gets excited when too many people show up. You can tell me if this actually is the case or not. I had read somewhere long ago that if you put up a beware of dog sign, that actually is your admission that there's a dangerous dog on premises, so you should never do that. That's one thing. But does when it is written into a lease, no pets, and he has a pet on hand anyway, and the pet causes an injury to someone, does the landlord then become liable because he did not hold the tenant to the terms of the lease? Yeah,
I think that's going to be pretty case-by-case basis. I've seen situations where landlords say, no pets, and then the landlord never comes around, doesn't monitor the tenants at all, and the tenants have dogs or whatever other pets on the premises. And I've seen it in the context of causing property damage, and then the landlord comes back and says, you shouldn't have had pets there. And there's a question. Okay, they weren't supposed to have pets, sure, but did the landlord see the pets or didn't they? And did they make essentially waive that portion of the lease if they did see them and didn't say anything?
Okay.
So so that from that perspective, and I'd assume the analysis would be similar. From an injury standpoint, but as a landlord, you're going to want to enforce things in a lease, and that's a general proposition. It goes past the idea of pets, because if you have a provision of the lease that says, okay, you've got to pay your rent by this day, or I'm going to charge you a late fee. And then every month for 6 months, the tenant pays the rent 2 weeks late. You don't charge them a late fee, and then you go. Then you're trying to evict them later for not paying their rent. And you're trying to tack on all these late fees, and you go to you go to court and say, well, they owe me all these late fees. No, you've kind of waived that because you didn't enforce it to begin with. So you can have a provision in a lease that is a no waiver provision. Says, hey, even if I decide to be nice and not enforce something very strictly, that doesn't mean I'm waiving my right to it. So that's another good reason to have a lawyer look over your lease.
Yeah. I guess from the landlord standpoint and from the tenant standpoint, really paying attention to what is written into that lease becomes very, very important. And I would guess as well that from both of their standpoints, when you're confronted with a lease, you ought to have an attorney review it and point out, where are the problems, where are the potential areas where there could be a dispute.
Yep. Even from a from a landlord's or from a tenant's perspective. I've had tenants come in, almost every tenant that I've ever had come in to ask me to review a lease ahead of time, which isn't very often because normally, they just sign them and move on and don't really think about it. But they usually come in, sit down and say, well, I'd like you to review my lease, but I'm sure it's just a standard lease and it's like every other one you've ever seen. But it never is. There's always something there that's particular to this situation, to this property, to this landlord or this tenant or all sorts of factual differences can make a difference in that document and the way you're interpreting it. So it's never the same, and that's the fun thing about practicing law. Even something as simple as a residential lease it varies from situation to situation. You're always looking at something new.
Always something pops up.
Yeah.
I guess mom and dad who are sending kids off to a school either here at IUP or some other college somewhere else, and those kids are going to be signing rental leases, maybe they ought to make an arrangement to see an attorney about what that lease is before it's signed too. Yeah,
let me, and I'll tell you this, and I know I'll probably leave you with this little anecdote. So I've had a couple of situations similar to this where a parent sends their son, daughter to IUP here to be a student. They sign a lease, and as is common with student rentals, it's a lease for an entire year. And these things aren't the rental rates are they are what they are. They're market rates, and they're not cheap. And the parents are usually, and not in every situation, but usually relying on the student's financial aid to pay those rental for that apartment. So what happens? First semester rolls around, maybe several weeks into the first semester, and son or daughter gets sick or has some other personal situation, and they don't stay at school, or they get through the first semester and they're failing out. So they need to go home. Mom or dad says, "Yeah, this isn't working out. You need to come home. Maybe wait a year and mature before we send you to school." And what happens is the landlord can come and say, "Okay, you still owe me for the entire year, even though you don't have the money coming in that was earmarked to pay for this." And even though you've, and I've even had it be a case of domestic violence where you've had a young woman that was, brutalized by a significant other. She had to go home. They said, "Well, you still owe us $6,000 for the rent, even though you're not here." And Pennsylvania law permits them to do that. So that's something that, and we can, that's something that can be addressed up front as to what happens if you terminate a lease, if you need to terminate a lease for something outside of your control or early. So, that's something, absolutely. Get it reviewed and at least know what your rights and obligations are.
All right. So in order to do that, contact Marshall Chriswell for one. And to do that, what must they do?
The phone number at my office is 724-465-5826. The website is westernpalawyer.com, and we're here in downtown Indiana in the Atrium Building.
Thank you, sir.
Thanks a lot.
AM 1160 WCCS, FM 101.1.